Good afternoon, everybody. You're all very welcome here to our session on the European Social Charter, a story of equality. And obviously, I hope we're all looking forward to the session and looking forward indeed to all the multitude of activities that are happening over the next couple of days. Our session today is focused on equality. Coronavirus obviously has brought to the fore the differential impact that pretty much, like in this instance, the health crisis can have across a range of vulnerable groups. And there's been a huge recognition of the need in moving out of coronavirus to build back better so as that we come out on the other side of coronavirus as a more equal society. But it's easy to say that. I suppose it's more difficult to deliver it. And the focus of the session here is on the question of the tools we have to build back better, and particularly one tool, the European Charter of Social Rights. So what we're doing here today is looking in particular at the principle of non-discrimination or equality that's incorporated in the Charter. And we're looking at a particular example in terms of how that principle has been applied in a case to do with people with disabilities to make a difference to the opportunities that that group face in society. So that's, I suppose, what we're looking at. And we're looking at it through the fact that a particular collective complaint was brought on the access of children with disabilities to mainstream education in Belgium, and the type of change that was able to bring about in state policy and practice. So it's important to emphasize that there's a lot of different actors involved in these collective complaints. And what we're going to be doing today is hearing from actors from a number of the different parts of the collective complaint process. But before we do that, I just want to remind all our audience here, and say you're all very welcome, that you have access to put your questions and comments into the discussion through Slido, and you should have got instructions about how to use that in the correspondence setting up the session. But right at the beginning here, I'm just going to ask you to use Slido to just answer one question. Can you please very quickly name one right from the European Social Charter? Just give you a moment to answer that question. So if you can just please name one right from the European Social Charter, and our colleague Darius, who's moderating the Slido for us, is going to present some of the answers here as they're coming in. So over to you, Darius.
Yes, hello everyone. Thank you, Lawrence, for this introduction. Well, so far, participants seems to be still getting familiar with the Slido, and we have not received responses so far. So perhaps participants are not able to name only one of the rights, including the Charter, because they are all important. So I will pick a side, and I will say the right of persons with disabilities to independence and social integration and participation in the life of the community, Article 15. But also Article 13, the right to social and medical assistance. I think is important, but I will not provide more spoilers to our participants, and I will give the floor to you again.
Okay, thanks very much. And obviously, participants, we'll keep an eye on that, and we'll check back in through the session if interesting stuff comes in. So we'll move on then. I just want to introduce, as I said it before, we're trying to bring together different actors from the process of the collective complaint. So we have three speakers with us here today. We have Aoife Nolan, who's Vice President of the European Committee of Social Rights, which is the implementation body for the Charter. And Aoife, you're extremely welcome here today. Delighted to have you here with us. We have Anne Campbell, who's the co-executive director of Validity, which was previously the Mental Disability Advocacy Centre, which brought the collective complaint. And we have Carol von Baselaar, who is from the Centre for Equal Opportunities and Opposition to Racism and Discrimination, that's Unia in Belgium, who are all going to present. So they'll be coming in as we get to them, but I'm going to start with Aoife, and I'm going to ask Aoife at the outset to briefly introduce the particular case we were talking about and explain why this case is relevant today.
Fantastic. Listen, thank you for that excellent introduction, Lawrence. And it's, oh, my camera appears to have frozen.
We can hear you, Aoife.
Sorry, 2 seconds now, and my screen will reinvigorate. I'm glad I want to say what a pleasure it is to be here.
I'm not hearing Aoife, and I just want to check if other people are hearing her.
No, she seemed to have an issue, so maybe I will contact her to make a connection.
Okay.
Please go proceed. Yeah, I will check with her.
Okay, I think we're going to have to just move on and come back to Aoife when we've got her sorted again. It's a little complicated because she was going to explain the case to us that we're going to speak to, but perhaps then I'll move on and I'll just ask Anne Campbell, if she could say a few words about the situation of the people that approached you with the case and why you decided to bring this case before the European Committee on Social Rights.
Sure, thanks, Lawrence. I mean, maybe I can very briefly just say what the case was about as well, while Aoife's off the call. So it was a case that we submitted in 2014 together with an organization called GRIP, or Equal Rights for Every Person with a Disability, which is a Dutch organization that's run by and for people with disabilities, that asked us to support in their ongoing fight for the right of children with disabilities to education in Belgium. The case was filed under Articles 15.1 and 17.2 of the revised European Social Charter, which are the rights of persons with disabilities to full social integration and participation in community life, and the right of children and young persons to free primary and secondary education. And Article E relates to the right to non-discrimination, which is not a standalone right. It has to be argued together with another right in the convention or in the charter. The complaint argued that the Flemish government in the Flanders region of Belgium was violating these 3 articles by failing to provide access by children with disabilities to mainstream education. And the reason that we, together with GRIP, decided to focus on the Flanders region was because at the time that we filed, 85% of children with disabilities were excluded from mainstream schools in that region or had no access to any education at all. Across Belgium, that amounts to approximately 46,000 children who had no inclusive education. Children with intellectual disabilities were the most excluded, especially those with higher support needs. Mainstream schools at the time had space for only 100 of these children. The right of children with disabilities is also guaranteed in the UN Convention on the Rights of Persons with Disabilities, and in its decision, the committee relied and incorporated significantly the language of the UN Convention in finding a violation by the government of Belgium, which was a very welcome finding. Children with disabilities have a right to be educated together with their peers in mainstream schools so as to ensure their sense of dignity and self-worth, and to ensure that they can achieve the full development of their potential, their personality, their creativity. The education system.
We might just jump back to Aoife then, and maybe Aoife, you could say a little bit more about the case from the point of view of the committee.
I absolutely could, but I think it was really invaluable actually having the whole thing set up by Anne so effectively, and I apologise, Teams kicked me out for reasons known only to the platform. But thank you, Anne. So you have this fantastic background that Anne has given and that I know that Carol will input as well. And so essentially our decision making focused ultimately on, while a number of different articles were argued, we ultimately found that there was a violation of Article 15.1, which is the rights of disabled people under the Charter, on the ground that the right to inclusive education of children with intellectual disabilities wasn't guaranteed in the Flemish community of Belgium. And we also found, importantly, that the same provision was violated due to a lack of an effective remedy against the state refusal of enrolment in mainstream schooling for children with intellectual disabilities. And as Anne has already highlighted, and as I'll say a bit more in a second, the position of children with intellectual disabilities was a key issue in this decision. This was even within a disadvantaged group, you had a particularly disadvantaged segment for the purposes of education in the Flemish region. And then finally, we also found a violation of Article 17.2 of the Charter on the right to education on the grounds that mainstream educational institutions and curricula weren't accessible in practice to the children concerned. Okay, so it was a violation both of disabled persons' rights and the rights of children, okay, because the case is about disabled children. So it's an example of how the group-specific provisions, both for disabled people and children in the Charter, can be brought together to deal with what is effectively multiple or intersectional discrimination. And so what we did, this was one of the things that's very striking about this case and must have been frustrating for the complainants, was that the complaint was registered in August 2014, but there was no decision until the 16th of October 2017. And it had gone on for so long that in fact, in the interim, a second complaint focusing very much on the same facts had been registered. And I'll come back to that because we've made a decision in that complaint since as well. This was an important complaint because it was an opportunity for the committee in our collective complaints law to really engage with the notion of inclusive education and to push forward our understanding of that, particularly with regards to mainstream education and children with intellectual and in some instances severe intellectual disabilities. We did note that various measures have been adopted by the Flemish community which aim to ensure that every child with a disability had access to inclusive education. And our decision focused in particular on the adoption of something called the M Decree, through which there was provision of some additional funding and transfer of staff from special to mainstream schools. However, we were clear in our decision that the M Decree, this system in the Flemish community, still maintained a difference between special and mainstream schools. And ultimately what the committee wants to see is children, whether they're disabled or not, in mainstream schooling. We noted that the integration programmes put in place by the Flemish community, but we said that nothing showed that those programmes had guaranteed the transition to inclusive education for disabled children. And we specifically said there was no evidence showing that integration leads to inclusive education. So you can see our direction of travel here. We focused in particular, as I've said, on children with severe intellectual disabilities. We noted that 0.1% of school, that a significant number of children with disabilities were exempt from compulsory schooling and didn't receive any education at all. And we found that the government failed to support its claim that the exemption of this group of children with severe intellectual disabilities was justified. We argued that we found that the government failed to support its statement that this was justified by an objective and reasonable justification for not providing reasonable accommodation to children with serious intellectual disabilities. And we concluded that this group was discriminated against on the basis of their severe disability. We also focused on the fact that once children were in the mainstream system, pupils with disabilities faced severe barriers with regards to reasonable accommodation. And we made clear that we considered that the state's failure to make provision for reasonable accommodation violated the child's rights not to be discriminated against in terms of its rights, in terms of their right under Article 15. And in other words, and we actually said that the failure to provide reasonable accommodation constitutes discrimination on grounds of intellectual disability. So a very strong statement. One final thing to note is we focused in on the question of resources, right? We're well aware that education is expensive and the government raised this, right? And the M Decree, of course, did allow for budget transfers, okay? So the government was able to point at doing something. However, the obligation under Article 15 is that states must make maximum use of available resources. And we noted from the on the information that we had that the M decree just provided for budget transfers. Okay, any funds not spent on special education are to be used for the benefits of children in mainstream or special education. And we noted that, in short, with regards to the M decree and funding overall, there was a risk of gap between financial needs and supply in terms of places and support for children with disabilities. The government provided no information as to how it planned to ensure the right to inclusive education for children with disabilities, and it failed to establish why it would have been impossible financially and administratively for it to take new measures to ensure reasonable accommodation to children with disabilities to attend mainstream schools. And in doing so, we stressed the fact that, the government had failed to establish that it was using maximum available resources, and it had failed to guarantee the right in practice. Okay, so ultimately we concluded that there was no evidence the M decree sets out a time frame for implementing the right to inclusive education. There were no indicators of successful measurable progress. There was no adequate monitoring or evaluation of the measures taken by government. And so we ultimately concluded that the refusal to enrol children with intellectual disabilities in the mainstream school system wasn't justified by any legitimate aim. Okay, now there were other aspects to our decision, but those are the key ones. I want to flag, however, that in our 2020 findings at the end of last year, we found that sufficient steps, and this is of course almost 3 years after the complaint, we found that sufficient steps still had not been taken by the Belgian government to remedy the violations in the MDAC and Belgium collective complaint. Okay, so this is an outstanding problem. Furthermore, in a decision of 9th of September 2020, which was brought by FIDH, and in which we found similar violations, showing the ongoing nature of the situation. Right, so there's clearly a huge issue with regards to what's happening in practice and what Belgium's charter obligations are. More positively, following the FIDH decision in September 2020, we saw a committee of ministers adoption of a recommendation. And while on the one hand, this was significant because it made clear that there were problems in Belgium and with the performance of Belgium, very importantly, it also showed the commitment of the Committee of Ministers to inclusive education for people with disabilities, including those with serious intellectual disabilities. So it's both a story of still a lot to do, but also of great hope as we move forward.
Thanks very much, Aoife, for that very comprehensive overview, and obviously a lot of key elements within that decision, which I think we'll all want to look into further. I'm just going to try and bring in now our third speaker, Carol van Baselaar from Unia. So, Carol, what was the role of Unia and why did Unia get involved?
Yeah, thank you very much. So our role was to submit observation, also called amicus curiae or third-party intervention, to the committee on the basis of Article 32A, paragraph 1 of the committee rules. And so this provision allows the president of the committee to invite any organization or institution or person to submit observation. And so why did Unia get involved in this way? But first of all, for reasons related to our mandates, as you mentioned it, so Unia is an equality body, an HR right, and also the Belgian independent mechanism which monitors the implementation of the Convention on the Rights of Persons with Disabilities. So you understand that Unia strives to ensure inclusive and equal participation for all and for persons with disability in society, and inclusive education, which is essential to ensure an inclusive society, is one of our top priorities. And however, as it was mentioned, Belgium is not a good student for inclusive education. And so we wished signal to the committee that the case was significant and raises issues of legal interest. And with what Aoife just said, it just to show that it was a very important issue for Belgium and for all the international human rights. And third, maybe briefly, so we have experience with observation to the committee because we already submitted a contribution in another case regarding Belgium. And two last points, because I know the time is very is very short. So we also have an important interest to see the development of jurisprudence in terms of inclusive education. So it was very important for us to see these decisions. And the last but a very crucial point is the importance of having a pre-existing collaboration with civil society and with GRIP, so the association which was at the origin of the complaint. And so we know the complaint will be before the court, and so we can help them and to work together for this important issue.
Thanks very much, Carol, for that. That's very interesting. Just to all the audience listening, obviously, you can put your questions to the speakers through on Slido. So anything you're hearing as you go along, just put questions through on Slido and we'll be bringing those questions in as we go along. I just want to check back in with Darius. Darius, have we received any questions at this point? Are there any questions that should be brought forward for the speakers? I have a couple in my own mind, but I won't throw them in first.
Yeah, sure. Actually, speakers are, they have asked a question, which is addressed to no speaker particularly. So any of you who want to answer is welcome. And the question is the following: what can persons with a disability do when they are discriminated? What can they do when the national judicial procedure takes too long? I'm not sure if any of you want to answer this question, and particularly from the perspective of the Charter. Thank you.
Well, I mean, if from the perspective of the Charter, forgive me, and I know Carol and Anne will have other thoughts on this, but I think the important thing to note is that we don't have an individual complaints mechanism. It's a collective complaints mechanism. So if you look at the additional protocol, which perhaps someone can put the link in Slido, you'll see that there are certain organizations that can bring complaints about really, really systemic and wide-ranging issues. And that's very much what happened in the MDAC case. And Anne might talk a bit more about that. So you could, part of it isn't just about an individual bringing a complaint before the court. It's a collective complaint. The other thing is, though, it's worth noting that unlike, say, the European Court of Human Rights or UN treaty bodies, the additional protocol, which sets out the collective complaints process, doesn't require exhaustion of domestic remedies in the same way as those other systems do. So in fact, if there's a problem, the fact that there is an ongoing domestic process may not bar it from being heard by the committee. That said, it's very unusual for people. It is relatively unusual for people to come with ongoing cases, if that makes sense. But it's not a specific bar in the additional protocol.
Anne, please.
Yeah, I can come in on that as well, just from because Validity specializes in strategic litigation, so we know how incredibly painful it can be to get through the domestic level proceedings. It can really take a lot of time sometimes. So the collective complaint mechanism under the Charter to the committee is one of the effective mechanisms that you can use without exhausting if you are taking a collective action rather than individual, as has just said. But there are also options under the UN, for example. So if your country has ratified or signed up to one of the UN treaties, in this case specifically the Convention on the Rights of Persons with Disabilities, you can also take what are called requests for inquiries. So you can write to the committee concerned and request that they open an inquiry into a systematic or grave violation of rights. Again, that's not an individual mechanism, it's a collective issue. We have done that ourselves as Validity against Hungary and had some success with it. But if you're looking for individual mechanisms and you really can't exhaust domestic remedies or get through the national system, it's possible to reach out to the UN special procedures, which are called special rapporteurs or working groups, and you can send them an individualized, immediate complaint setting out what exactly is happening to you or the person that you're concerned about, and they can decide to then reach out and intervene directly with the government. One other option is, and this is a little more technical, but it's a possibility, is if, as Validity, we've discovered that the European Commission often funds human rights violations such as segregation. And it is possible, if there is a European Commission funding in the issue, you can make a complaint directly to the European Commission. The only other thing that we sometimes use is to reach out directly to national ombudspersons or NHRIs, which I'm sure Carol will speak a little bit more to. But there are some options out there, and Validity is happy to help or to provide guidance on that if you're interested and want to contact us.
I just checked back, Darius, are there other questions?
Well, if I just can.
Okay, go ahead, Carol. Yeah.
Just once again to say that at the national level, of course, so we can help children, students with disabilities. So if they feel that they have been discriminated, they can report to Unia, and so we try to reach an amicable solution. And if it doesn't work, we can file a lawsuit also. But we know it takes time and it's yeah, very complicated. But just. Yeah.
Thank you very much, Carol. Darius, is there another question?
There are no more questions.
Could I just maybe ask a question? Because I was intrigued by your comment, Aoife, and it doesn't surprise me, obviously, based on experience in different countries, about the fact that a decision is made some years ago and a number of years on, the situation hasn't fundamentally moved forward. And obviously, the committee itself is trying to press on to ensure implementation takes place. And you mentioned some of the mechanisms, but I'd be interested to hear about how a decision like this is taken on board by people active. I'm thinking about the people who came to you in the first place, and are they able to use the decision in any way to try and leverage change in their own circumstances? So do they have to wait, if you like, for the implementation procedure that might be coming from the Committee of Ministers, or can they have they been able to use it to get any advances in practice, or has nothing changed over those 3 years? And that's open to anybody to throw in, but I just thought, Anne, you might know, based on the fact that you had engaged with the people taking or experiencing the issue.
Sure, yeah, that was something I was going to address actually when you asked the next question to me.
Okay.
But I can address it now either, whichever is easier for you.
No, I'd say it'd be good to have a little bit of think about this, because it's one thing to talk about the impact, the result of a legal case, but it's trying to see how that filters into actual practice on the ground.
Yeah, so from my perspective, the request to the committee and the collective complaint really arose directly from the national level advocacy that was being carried out by organisations of persons with disabilities and NGOs on inclusive education in Belgium. And the national level advocacy had already led to some action, but when they saw that the M decree was being put together and likely to be enacted, but didn't guarantee a right to inclusive education or allocation of sufficient resources, then the option to file the complaint was raised, and the decision was made to do that. And in the course of the litigation, while that was filed, it really generated a significant amount of discussion and debate at the national level. And in the course of the litigation, while it was ongoing, there was, we did note a reduction in the number of pupils in segregated education at the beginning of the litigation, which we put down to a result of complaints along with other factors. The minister, so GRIP carried out a significant amount of advocacy at the national level while the complaint was ongoing, and we did see some progress in that the Minister of Education, for example, published a circular to schools supporting a right to enrolment in mainstream schools. And just before the decision of the committee came out, an additional 15 million euros were invested in providing support to children with disabilities. We also saw that after the decision, because of the awareness that had been raised around the issue and around the facts in the complaint, parents began to use the National Level Commission on Pupils' Rights more frequently to assert their child's right to inclusive education, and we saw that most of those complaints were successful. So there was some progress in that way because of tying the ongoing pressure on the government through the complaint and the decision to the ongoing national level advocacy. Maybe I'll say a little bit more later.
Yeah, that's really, really helpful. And I think it emphasized the point, and not least to the first question, that for people bringing complaints, you know, the idea that you have to wait for several years, like you can still be active. I mean, it's a long haul, obviously, but I think that's very helpful. So, Aoife, you want to come in on that one as well? And
I just wanted to come in quickly and say that obviously one of the things you flagged there is this implementation gap between you make a decision and then is it implemented. Now, obviously, this is an example of where a decision was not fully implemented straight away, but there has been very good progress. And this implementation gap, obviously, between what an international human rights body decides and what happens on the ground, is obviously, that problem is not specific to the European Social Charter. But I do think it's important to note that the process does mean as well, when the government comes back to us with follow-up, they do produce information as to what they've done to change the situation. So while the collective complaint is obviously the legal assessment of government conformity, there is an ongoing engagement between the committee, ourselves, and the government with regards to whether or not they've resolved the situation. So, for instance, the government came back and said, oh, we're entirely revising this M decree. And the committee said, well, that's lovely, but actually it's not exactly clear what you're going to do, and you're not going to be clear about that until 2021. So it's not enough to say it, you have to do something. So, you know, you have to make clear what you're doing specifically. And that, again, is an ongoing pressure. It's an ongoing engagement with the government. And of course, as part of our follow-up process, we got fantastic information both from Validity and from Unia, which meant that we knew what was going on the ground. So we were able to maintain the finding of non-conformity on the basis of that information. That's a very important way in which civil society, you know, linking to some of the other things we'll talk about, civil society and NHRIs, that work of engaging and providing us with information is invaluable in terms of keeping up the pressure on government where they haven't responded to our decisions.
Yeah, I think this is making the link into the second part of our discussion, which is really about that the dynamic relationship between, if you like, the committee and the decision-making bodies at an international or regional level, and activism and organizations, both equality bodies, NHRIs, but also civil society on the ground. So I might just come to you then, Carol, in relation to that. You might want to give your thoughts on the previous question, but linking that to a more general question about how advocacy by civil society can become more impactful in terms of actually achieving change, and how can NHRIs and national equality bodies assist as allies in that process? So
yeah, it's an important question, and we could list various elements that contribute to making advocacy by civil society more impactful. But what can I say from our perspective, so from our NHRI's perspective and experience, is the importance, and it's just what it was said before, so bringing the voice of people, victims of discrimination, of violation of human rights, because without having knowledge of what happens on the field, sometimes in closed environments, it's very hard for us to know which direction we have to take, and sometimes we underestimate problems on the field. So I think it's the main key is to bring the voice of persons victims of discrimination. And another important point is to develop partnerships with us, so with NHRIs and institutions, because, for example, in this case, thanks to our collaboration with the Belgian civil society, we were kept informed of the different stages of the procedure, and so we were able to organize our work according to the deadlines and so on. So it's quite a detail, but it's very important for our daily work. And also we can also point out sometimes it can be essential for civil society to join forces with other associations. So in Belgium, for example, we have a collective that brings together disability association for all issues related to accessibility. And Unia can see that this has a very important influence on their legitimacy for the authorities to bring a collective voice. And another very important point is to collecting data and to make publicity over this data and using the media. I think it's very important. And regarding the second aspect of your question, so how we can assist civil society, I think first of all is sometimes informal exchange that can prove decisive consequences, such as just networking, exchange contact information, connect people together, and to give people the right person at the right place to have the good information. For example, about the reclamation for the French community in Belgium, the reclamation was made possible because one of the parents of persons with disability knew a very eminent jurist that can help to write the complaint. Also, Unia and NHRWise, we can provide civil society with resources to support their action. And example, on our website, we have developed a page with all the necessary information for civil society to participate in evaluation of Belgium by different UN committees. And more formally, also of course, we can help civil society to support their claims, for example, by this observation to the committee. And I think that what we could bring to the committee and to civil society in participating in the case was giving or an independent analysis of the situation in Belgium from conventional right of persons with disability perspective, and also to give the committee some relevant reports that we received in Unia about education and about disability. So the committee could see that the right was not effective in Belgium, that we received a lot of complaints about parents of children with disability, and mainly for children with intellectual disabilities.
Thanks very much, Carol. A huge amount in there. Obviously on a lot about evidence I hear, and that which we might come back to. Just Anne, just coming to you, just could you say a little bit more then about what you see as the role of civil society in engaging with the collective complaints mechanism, and how can civil society be supported by and support other actors in the process?
Yeah, I think the collective complaints mechanism is an important element in a strategy that civil society has around a particular issue. This is the way that we use it as validity. We don't see it as a means or an end in itself, but rather as a really important and impactful tool in a toolbox of activities that we can carry out. So from our experience, the committee's decisions are of paramount importance in setting out the law and setting out states' obligations, but civil society really has to do the work before, during, and after the proceedings at the committee to create real change. So this particular collective complaint, it took ourselves, it took GRIP. We were very much welcomed the intervention of Unia as well as an amicus in the complaint. But when the decision came out, we didn't see that as an end, but continued to actively follow up. And I think the consistent engagement of civil society with the entire process around the committee's reviews of states is important in this regard. So we used the committee's follow-up with the government to keep the pressure up at the national level, submitting, as Aoife mentioned earlier, an alternative report to the committee on implementation of the decision in 2019. The states have to report regularly on implementation of different articles of the Charter, and they were reporting on Articles 17 and 15 at that point. And the committee, if you request permission, does allow civil society to submit alternative reports. The government has stated, again, I think Aoife referred to this briefly earlier, that it wants to repeal the M decree. And so GRIP and others are continuing to lobby actively that any new legislation or replacement of that M decree respects the right to inclusive education. And GRIP runs an active network of experts by experience and professional experts that monitors implementation of the right to inclusive education in Belgium, supporting research and advocacy. And validity for our part, we continue to raise the right to inclusive education regionally and internationally at the UN and litigating at national and regional tribunals. But we're highly concerned that the new legislation that is being proposed could be a possible setback for inclusive education in Belgium. So from our perspective, it's important for civil society to keep engaging with the committee, to keep focused on follow-up and the reporting procedure, to keep that pressure on. But together with that as a strategy, we also believe that it's important to raise the same issues at multiple venues. So in shadow reports to UN bodies as well, but also to engage with the EU and the European Commission directly on related issues such as implementation of the EU Disability Strategy 2021 to 2030, which actually contains a strong references to inclusive education. It much like the European Committee of Social Rights, it emphasizes that special schools do not offer effective bridges to the mainstream education system, continued training, or the labor market. So it really takes a coalition or a movement of persons with disabilities and their allies to change the mindsets, policies, and laws towards inclusive education. And decisions such as those by the committee can be a solid rallying point for this. But it's important to recognize that there is and must be a lot of civil society action in addition to simply filing a complaint for there to be real impact.
Thanks very much for that. And just to remind our listeners that if you want to put questions in the Slido, we'll come back to that in just a moment. But I want to go back to Aoife now, just and I think you wanted to come there anyway, Aoife, but just to maybe ask if you could give us some sense. I mean, you've given a very good specific example of how the charter can be used to address some of the inequalities arising from COVID, or just more generally. Are there any broader lessons you think are here for thinking about how the European Social Charter is relevant to addressing the inequalities that have emerged through the COVID situation or have been made more visible through the COVID situation? But also maybe to ask you, partly tying into what Anne was saying there, how can NHRIs and national equality bodies and indeed civil society support the work of the committee effectively to bring about change?
I think I might actually start with answering that one, if you don't mind,
Yes,
Lawrence, and then skip on to the COVID-19 one. I think I've already made reference to the fact that bodies can provide information as part of our follow-up to particular complaints. So that's really useful in the collective complaints context. Another way in which organisations and civil society and NHRIs can contribute is through sending in third-party interventions. Effectively, that's not what we call them, but submissions. Even if, for instance, MDAC doesn't bring a complaint or Unia doesn't bring a complaint, they're not the complainant. They're able to provide a third-party submission, as happened in this case, and that's an invaluable source of information. So those are two ways. You can bring a complaint, you can do a kind of third-party submission, and you can provide information on follow-up. So those are three ways you could do it in the collective complaints process. However, and it was really great to hear Anne speak about this, a hugely important part of our work is, and it's a lot less sexy, it gets a lot less attention, but it's really important, is our reporting system, where states report periodically. And if you're an NGO and you do a submission to UN treaty bodies on social rights, for instance, goodness me, wouldn't it be interesting to just extend that slightly, tweak it, look at our mandate carefully, because it has to be focused on the charter, but provide information to us when we look at issues around disability or child rights or trade union rights or health rights, whatever. There's information on the reporting system available on our website. We look at groups of rights. We divide them into 4, all the rights in the charter, and we look at a different group each year. If you're working in a particular country and you have information on that country's conformity or non-conformity, say with labour rights, and we're looking at labour rights that year, send in a submission, we'll read it, it will be helpful, right? So that's another way you could input through the reporting process. With the COVID-19, we have, I think, rather than give you a lengthy, heartfelt statement about how the Charter can be used. I just refer you to our COVID-19 statement. We adopted this in April 2021. We took a long time to really provide a detailed statement and analysis of how we think the Charter applies to COVID, particularly but importantly, not just the short-term, say, school closures reaction, but also the much more long-term, dealing with the socioeconomic deprivation, the impacts on older and disabled people, and other disadvantaged groups of the COVID pandemic, and what we need to see happening in terms of long-term law, policy, and resource allocation. And essentially in that statement, we make very clear that the Charter should be a roadmap for government decision-making following COVID, in order to give effect to a more socially just and rights-compliant society. So it's rights not just as a way of protecting against government interference, it's also about shaping what governments do from here on in. So, and the statement, which I hope someone can put in Slido, is absolutely focused on that.
Thanks very much, Aoife. And I forgot to introduce myself at the beginning. I'm the director of the Irish Human Rights and Equality Commission. I just want to say, in relation to Aoife's comment about using the reporting system from a domestic point of view, we've been doing that over the last 4 or 5 years, and it has, it was slightly, as you say, and I don't mean an afterthought, Aoife, but everybody thinks about reporting into the UN bodies, and somebody had to say, why aren't we reporting into the committee? And we did it on a once-off basis, and frankly, from the first time we did it, we realized it was an extremely positive way for us to use our time, and an extremely positive mechanism for then us advancing the discussion around practical social rights domestically. So it has proven extremely valuable to us as an equality body, as an NHRI, and I can highly recommend it to other bodies to at least give it some consideration. I'm just conscious of time. Just want to check back with Darius. Is there any key questions coming through that you want to bring forward for the panel before we move on to the closing part of the session? Darius?
Hello, Lawrence. Thank you. We actually have no questions. This is good. Participants are really concentrated on the speech, but luckily for us, I'm aware that Lawrence, you did your homework and you have some more questions to ask our speakers this afternoon. So I will give you the floor back.
Yeah, I think we want to move on. I suppose the question here, and can I just say to all the participants here, I have found this fascinating to listen to myself. I think it's been a very concrete example of a really focused process. Challenging, difficult, none of these things are easy, and I've been very struck by the roles that different bodies can and have played, and I think that's really useful. But we were touching there on the implementation question. I suppose a key question really that I'd maybe give you like to hear from each of you, your observations is, we can see from this example that it's possible to stand up for equality through a mechanism like the European Social Charter. But what's next from your point of view in terms of developing that mechanism? How can we ensure implementation, and how can we ensure real change? Now, that's a big question. So, I mean, but I'd just like to hear your maybe individual reflections, and I'll come to each of you in turn. So I might come to you first, Carol, just.
Yeah. So I think what we have to continue to do, it's an ongoing pressure on authorities, and for that we really need to making known these decisions. So for the Flemish part and the French parts of Belgium, and to all people. So just not only to authorities, but also for media, so they can influence the necessity for states to take measures to go towards inclusive education. And to civil society, I think it's really, really important to know about this decision and the impact they can have, because we can see that this decision are inspiring for people, and that some people, some individuals can struggle and force states to change their laws and take measures. So I think it's important. And what we can see also from our perspective is that authorities didn't always know the decision. So if you work with one person government and you talk about the decision, sometimes she doesn't know the decision, and I think it's our job to make sure that the decision is known by everybody, and to show that this is an obligation from human rights and not only a few people that complain for something. So I think that two important things to do for the future.
Thanks very much. Anne, how about you?
So, I mean, I think that the COVID pandemic really has changed the rules of the game and really changed the playing field when it comes to disability rights. And I think it's raised new challenges, but I think it's raised new opportunities where the committee and the charter can be one of a number of important mechanisms for taking advantage of those opportunities. Just in relation to Belgium, I wanted to reference a survey that we published in December 2020 called the Disability Rights Monitor. It was a global survey that had over 2,000 responses from people with disabilities and others from 134 countries. And there were 27 responses from Belgium, of which 19 were persons with disabilities and 4 were family members. And the findings demonstrated near total exclusion of children with disabilities from education as schools closed down and online teaching was instigated, and it was largely inaccessible to children with disabilities. Their needs weren't considered when measures were taken, and many didn't have access to the necessary technology. Respondents from Belgium, every single one, reported that the government had taken insufficient measures to support families of children with disabilities during the pandemic. But I think the pandemic has forced governments and the public to really face the harm caused by segregating persons with disabilities from society. And in particular, segregation in institutions led to incredible loss of life and hugely increased susceptibility to disease and death. And this has put the need for inclusion more prominently on the public agenda. It's become unavoidable. And greater public awareness is making it harder and harder for states to ignore their obligations in this. So using the opportunity provided by the Social Charter by filing complaints to the committee should be seen as one factor in a constellation really of political and legal avenues in Europe for implementation of disability rights. As Validity, we have filed a complaint to the committee seeking a finding that the restrictive measures taken during COVID discriminated against persons with disabilities and violated their right to inclusion in the community. But another key element for impact and implementation of these rights and for creating change in the future will be an emphasis on calling the European Commission to account where they directly financed segregation. So Validity is making this a priority to use the law to stop these investments by the European Commission, which amount to billions of euros every year. And I'll be speaking more about that tomorrow, actually, at 11:30 on the Fundamental Rights Forum. So I think using the multiple different mechanisms together with the Charter and using the opportunities created by COVID is I really have some hope going to move implementation forward.
Thanks very much for that, Anne. Very reflective. Aoife, what would your thoughts be?
I think very quickly, I think that Carol and Anne have covered their aspect, you know, the key element, key issues very, very effectively. I think I just want to, I suppose, make a plea, and that's that you have this charter. It's very wide ranging. 42 out of 47 Council of Europe member states are parties to it. Social rights have been hammered by COVID. And at the moment, civil society and NHRIs in Europe, with a few notable exceptions, are playing catch up. And I would say that it is absolutely crucial, if we're serious about social rights and we're serious about social rights in Europe, that there's some upskilling and that on social rights and the social charter, and there's a need for engagement, and that will take time and energy and effort. But what I will say, certainly hearing Anne and hearing Carol today and Lawrence's comments on, on his work with the Irish Human Rights and Equality Commission, is it's worthwhile, right? This is an important avenue. But we aren't able to do this work unilaterally. It is crucial, if social rights and the Charter are really to be given meaning, that civil society and NHRIs pick up the ball and run with it.
Thanks very much for that, Aoife. Thanks very much, everybody. I suppose we're coming to the close of the session. I suppose I want on behalf of myself and behalf of everybody who's attended to thank the speakers but I have to say I found an incredibly informative and reflective set of presentations. and thank everybody who has attended. I hope you found it equally useful. I suppose just a number of reflections in conclusion from myself. I mean, our opening question was really in trying to build back better after COVID, you know, how can we use the social charter and its procedures, or the European Social Charter's procedures? And I think what I hear today is a very concrete example of the relevance of the charter and its mechanisms. And obviously we're talking here about the collective complaint, but we've also referenced the reporting system of the charter to building back better in a way that I found very compelling and very concrete. And I think hopefully would recommend it to everybody. I think I am hearing this is not a quick fix by nature. These processes are not quick turnarounds, but the key role it can play in bringing about systemic change and policy change over time has been made clear here. But I think what has been emphasized is that, if you like, the technical elements of the charter processes, the complaint process itself and the reporting, have to be part of a wider process of looking for change, and in some sense they're mutually supportive. Like, you know, the action at a national level is supported by the action at the committee level, but equally the action at the committee level is supported by the action at the national level. And I think that I suppose brings across a crucial element of seeing the use of the social charter as a collaboration between a range of actors. It's not just about the committee itself, but actually about the people on the ground as well. And I suppose for the purposes of many of the people attending here, that second lesson is really crucial. And I would emphasize again, just what Aoife just said there, it seems to me to be a process that's underknown and possibly underused, although it's used very well when I have seen it used. And I think the examples here today show how well it can be used in a very practical way. So just to emphasize that to people. And I think just to emphasize the final conclusion for me is, I do think that the through all of these processes, Anna mentioned the point that no process is an end in itself. Its fundamental value is about, you know, it's a tool in a toolbox to be used when appropriate to do the job you need to do. And fundamentally, the job we're trying to do is to make practical difference particularly for groups that are excluded or experience inequality and rights violations. But so that focus on trying to be very mindful and practical about and strategic about using these tools to bring about effective change, and maybe opening up a wider conversation between NEBs, NHRIs, the committee and other actors at a domestic level as to how to really effectively use these tools. So thinking, you know, working on the assumption that these are tools that are there to be used, but we need to think very carefully about how we use them well in each case. But that there are my just general reflections, in many ways repeating what people have said. But I have to say, I found it's a very, very informative example and a very good illustration of the value of the social charter and the work of the committee, and to compliment Aoife and the committee on the excellent work they do, and indeed to compliment Anne and Carol here for their work on bringing forward the complaint or supporting the complaint. So I'm going to close the session at that. I hope everybody has found it useful. And again, on behalf of everybody who has attended, I just want to thank our speakers. And I don't think we can do it on Teams, but metaphorically, to have a round of applause for the speakers' excellent presentations here today. Thank you very much.